I really don't know if any of the senators over there are going to get their bills out today. Because today was the first time I could not go through that line and get up here to my chair. I had to go around this way. Too late now. Too late. Clear the room. All right. Chairman Green, would you open us with prayer, please?
Let us pray. Our Heavenly Father, as we come together this morning, may we come to do the people's business. And Lord, just direct us and guide us in the coming days. And Lord, let us know that everything that we do is pleasing to Thee. And Father, we just pray for the people of the Ukraine. We pray that You will continue to bless them. Bless their courage and bless each and every one for defending the freedom in their country. And Father, bless us and let us know that here in America, freedom is not free. Let us be mindful of that as we move forward. May God continue to bless this country, bless this great state of ours, and bless each and every one of us. In Thy holy name we pray. Amen.
Amen. Thank you, sir. Everyone, please fix your phone so it goes on vibrate, including me. You know, I heard the I heard this morning that, you know, we can see the light at the end of the tunnel. Now, we're trying to decide if it's the opening at the end of a tunnel or the train's coming. I hope it's the light at the end of the tunnel. Isn't this a wonderful day? Okay, Senators, Mr. Albers, go ahead. Tell us your bill number, tell us why this bill is needed, and what your bill does.
Thank you, Mr. Chairman and members of the committee. On the second page, the fourth from the top, Senate Bill 404. It's a very simple bill driven by the department that allows for our EMTs and our paramedics to keep their fingerprints on file, so when background checks have to be done, they don't have to resubmit every time they have to recertify. This will help our first responders.
Okay, this is a department bill, right?
Yes, ma'am. Yes, sir.
Okay. All right. Got anything else?
I do on the final page under Structure Rules, Senate Bill 330, Giving the Gift of Life Act. This bill simply makes sure that insurance companies cannot deny insurance, life insurance, or cancel it for those who have donated an organ like myself.
I'll tell you what, I am really impressed with what you did there. Mr. Stevens.
Thank you, Mr. Chairman. I think the bill is a good bill. It's just that I see a tax credit on here which is not sunsetted. I think everything that goes through the Senate has a sunset on it. Would the author mind a slight little fine-tuning?
Thank you, Chairman Stevens. I believe the version you have does not have one on anymore. I think it just has insurance. Good. Thank you.
Chairlady Smith.
Thank you, Mr. Chairman. Good morning, Senator. And I, too, thank you for what you did with organ donation. It's amazing. My question goes to Senate Bill 404. In the past, individuals who had to submit their fingerprints were concerned about the filing of their fingerprints not being securely stored. So has that issue been addressed?
Yes, and thank you very much for bringing up that important question. They are held actually by the FBI, and they are securely held. This just really helps out EMTs and paramedics like myself to not have to get re-fingerprinted. As we know, people's fingerprints do not change.
Thank you. Thank you, Mr. Chairman.
Okay, see no more questions. Thank you.
Thank you, Mr. Chairman.
Senator Kirkpatrick, I forgot to call you up. I think we have another female senator in the back. No, you're not female.
Thank you, Mr. Chair. What I have for you today is Senate Bill 339. It's almost at the bottom of your first page. And this, what it does, it expands the definition of a Maddie's call that is used for disabled adults and allows a checkbox on the GBI's form for military and veterans. So the form is completed by local law enforcement and transmitted to the GBI, and I work closely with the GBI on this bill and be happy to answer any questions.
Okay, see no questions. Thank you. Ms. Anderson, come on up. This is your first trip here, isn't it?
This session, yes, sir.
Okay, well, go ahead.
Well, good morning.
Good morning.
I just had a bill 279 that was presented to rules, but I don't see it on the list I showed up to.
Well, go ahead and tell us what it does since you're here.
Thank you, sir. Good morning, members of the committee. So Senate Bill 279 is a bill that would allow for a marker or plaque to be placed inside the Capitol commemorating the original 33. There is, from the previous sessions and times, and Senator who has statues outside from the Black Caucus, but this would allow for the marker to be inside the Capitol, as most people, when they visit the Capitol, don't visit outside. But these were the original 33 who were expelled because of their color, and it would place a placard or marker inside the Capitol as a point of history, because it's a very little known history fact in Georgia. So if there are no questions, or if there are questions.
I see no questions.
Okay,
Thank you, ma'am.
thank you.
Dr. Burke.
Good morning, Mr. Chairman.
Good morning.
Members. Senate Bill 496 is on the second page, about halfway down. And this bill contemplates death investigations on maternal deaths when they occur without a known cause.
I don't see any questions.
And Senate Bill 605 is on page 3, second from the top. And I presented this the other day. It basically allows a nonprofit organization to pay its unemployment benefits over a 3-year period.
Okay, I don't see any questions there either. Thank you, sir.
Thank you.
Mr. Gooch.
Good morning.
Good morning.
If it pleases the committee, I'd like to present 4 bills. First bill is on the modified open rule, first page, SR 463. It's a joint study committee on the electrification of transportation. This deals with an important issue that we've been talking about some this year with the electric car industry that's emerging rapidly throughout our country, dealing with charging stations and how do we tax automobiles that are driven by electricity rather than motor fuel. And so this issue needs to be studied throughout the summer and the fall, when it'll be a joint study committee between the House and the Senate, and the Speaker and the Lieutenant Governor makes the appointments, and it also adds the Department of Transportation Commissioner, the Commissioner of Economic Development, and one other party, the chair of the PSC. So those 11 members will study the issues and make a full recommendation by December 1st of this year.
Is Mr. Jaspers going to be on that committee?
Yes, sir.
I just want to be sure.
As long as he remains the chairman of transportation.
Well, that's kind of iffy sometimes. Okay.
Next bill is SB 529, which is on page 2, a little below halfway down. This deals with franchise fees and streaming. I mentioned this last week. Currently, we do not allow franchise fees to be charged to apps that are on your television, like Hulu, Netflix, Disney Plus, Sling, and so forth and so on. There's probably dozens of them. Franchise fees is simply a lease of the right-of-way for a municipal right-of-way or a county right-of-way. There are 3 entities in Georgia that have tried to place such franchise fees on these kinds of downloads and this streaming, and it's just not legal to do so, but this clarifies state law in that regard.
Okay. Oh, hold on, Mr. Hawkins.
This is a question on 463, Senator. I had a bill last week in Senate, and they amended the bill from Lieutenant Governor making selections for a study committee to the pro tem. But yours says Lieutenant Governor?
Yes.
Okay. I was just told that that was the Senate's position.
I think there was another piece of legislation that had that language in it, but not this one.
Yeah, okay.
Thank you. Next bill is SB 558. This is the annual housekeeping bill that you see coming through the House and the Senate. There was 3 sections in the bill. The first deals with how we notify legislators of a DOT board member election coming up. The second deals with just some cleanup language on RFPs and the revisions of a proposal that's being considered. And the third section deals with the concealing of data in express lanes and so forth. So this would exempt personal data from being exposed to open records request. So that's all the bill does, those 3 sections. And the last bill is SB 586. That is on page 3 at the top. It deals with design build concepts for procurement. Currently, the DOT uses a procurement method called design build. That's where a proposal comes in. A general contractor can actually hire the architect to do the design, and they also do the bid work, and they do all of the construction work. There's a requirement that 30% of the work is done by the general contractor that submits the bid. We're already doing that in state law for GDOT. This allows counties that same privilege. That's all the bill does. And this was at the request of Forsyth County Manager Kevin Tanner.
Oh, okay.
That's all I have this morning.
Now, do you think mentioning Kevin Tanner's going to help you out on your
You know, if Kevin's listening right now, he's probably chuckling, saying, "This is a good bill. I need y'all to help me get this bill out."
Okay, well, thank you, sir.
All right, have a good day.
Mr. Robertson.
Good morning, Mr. Chair and committee members. Mr. Chair, my first bill is SB 183. It's the second on the modified structure rule list on the first page. It deals with the Office of the Sheriff and other issues. What this does is require that sheriff candidates be qualified as post-certified law enforcement officers prior to qualifying to run for that particular office. There's also language in the bill that allows local governments to install speed detection devices within school zones, and language in there that determines how the civil penalties are paid in order if an individual trades in a vehicle that has one of these types of citations associated with it, that the citation is directed to the driver and not to the vehicle. We found in the past that some of these vehicles, when they're traded in, if they have these types of civil penalties attached to them, that the auto dealers are the ones having to pay the civil bill. That's SB 183.
Okay, so you're, Mr. Williams.
Thank you, Mr. Chairman. I think I missed part of it. Is this bill saying that to run for sheriff, you have to have been certified?
Yes, sir. Other parts of the criminal justice system, such as district attorney, judges, and others, have pre-qualifiers in order to run to make sure that the individual has the basic knowledge to hold that office, and all this does is the same thing. This would require a candidate running for sheriff to have the same basic skills that a rookie police officer coming out of the academy would have.
One follow-up, please.
Yes, sir, please.
It's been a lot of years that hasn't happened. I can understand that judges, because there's a requirement for a law degree, but I've seen some mighty fine sheriffs that have not been certified prior to, but they do go and get certification before they can be sworn in.
Yes, sir, and we have had instances where individuals were elected to that office and had difficulty going to do that. The sheriff that hired me initially back in 1985 was one of the sheriffs that you speak of. He was, when he came onto the job, he when Sheriff Rutledge first ran, he was not post-certified, and he became post-certified after becoming sheriff. But we have ran into problems in recent years where individuals had difficulty passing the basic course because of additions of EVOC courses and other types of courses that require certain motor skills and things of that nature.
Ms. Ballinger.
Thank you very much, and I appreciate your bringing this bill. Just for clarification, there's no substitute allowed for post-certification, correct? So you can have a retired ATF agent, a federal agent, somebody who's obviously very skilled in the area of law enforcement, but they would have to go back and take how to apprehend a subject and that sort of really rudimentary basic classes in order to be sheriff after retiring from 30 years of federal law enforcement, correct?
That is an excellent question. Yes, ma'am. We recently had someone who applied for the police chief's job of the Muskogee County School District, and he was a retired federal agent and was required to go, and because he was not Georgia post-certified, he was disqualified. And for him to qualify for that position, he would have to go to the mandate class here in the state of Georgia along with other rookie police officers, deputy sheriffs, and others, and successfully pass that class in order to qualify to be the chief of that agency.
That obviously being an appointment process, but shouldn't the voters be allowed to decide who is and isn't qualified to be their sheriff?
Well, yes, ma'am, and I think, again, back to the requirements of district attorneys, judges, all judges in most cases, unless they are appointed, I think the basic requirements, walking in the door, gives the citizens the opportunity to understand that this individual not only has the skill set, but the dedication to hold that position.
Okay.
There's a lot of liability associated with these types of positions within the criminal justice system.
All right, thank you.
Thank you, ma'am.
Mr. Wilkerson.
Thank you, Mr. Chairman. I think I lost track. So this bill deals with sheriffs, tickets, and school cameras. Is that, could you just summarize, I guess, what it deals with again?
Yes, sir. It deals with the qualifications of sheriffs, and then it deals with the traffic cameras within school zones and how those citations are assigned to the individual driver and not the vehicle. So the civil citation associated with the speeding cameras and the speeding cameras are one part of the bill, and then the sheriff's qualifications is the top part of the bill.
Is that it? Okay. All right, yes, sir. Oh, hold on. Does 38 have a question? Okay. All right, next one.
Mr. Chair, it's SB 556 on page 2, third from the bottom. It says driver's licenses. It actually what this bill has become is this bill now contains the language that we had in the traffic stop education legislation that passed through the House, passed through the Senate last session, then passed through the House with some changes. And when it came back across to the Senate side, I agreed with the changes, but my fellow senators did not. And so that it failed over in the Senate on agree. And so this year, the language is now in SB 556 after it was determined that free driver's licenses did not have much interest. Most law enforcement officers do not want free stuff, including driver's licenses that all other citizens have to pay for.
Okay. All right, see no questions. Thank you, sir.
Thank you, Mr. Chairman.
Mr. Hatchett.
Good morning, Mr. Chairman. Today I bring Senate Bill 479. It's on page 2, 5 down. This is Governor Kemp's bill, and what it does is it corrects the criminal code to reflect the initial intent. If you're a convicted felon and you're in possession of 1 handgun or 5 handguns, under current law you can only be charged with possession of 1. What this bill does is it clarifies that, and you would be charged separately per firearm that you possess.
Okay. Now, I'm going to ask you the same question I asked Mr. Gooch a while ago. Just because you referenced Kemp, does that mean this bill's important?
It does.
Okay. Just wanted to be sure.
Thank you, Mr. Chairman.
All right, thank you. Goodness, I've seen you here before.
Yes, sir. Thank you, Mr. Chairman, members of the committee. Thank you for having me today. I'm just here to present Senate Bill 397. It's Governor Kemp's bill. It's high school equivalency legislation. This is really a simple bill. In 2020,
It better be.
In 2020, the state now has multiple pathways to get your GED. In the past, it was only the GED. Now we have High Set and we have Career Plus. These new pathways are not eligible currently under statute to be for the GED voucher. So this is cleanup language in that regard. And also, when you complete your coursework, in the past, you've had to pay out of pocket to take the tests, and what we're trying to do, we've seen a decrease in people taking the tests. We're trying to move the money from the back end to the front end so that folks will not have to, if you're a single mom with 2 kids, you don't have to come out of pocket to take the tests. We've got over 1 million Georgians, adult Georgians, that do not have a high school equivalency. So this is legislation to try to address that. Be glad to take any questions, Mr. Chairman.
Chair Lady Smith.
Thank you. Thank you. I'm over here back against this wall. Good morning. Thank you so much for looking into the cost of the test for so many of our Georgia citizens who are trying to take the test, do not have the money, and communities are having to try and find grants and trust to help them. So thank you for bringing that to us.
Yes, ma'am. Thank you.
Well, is this your last bill here today?
Yes, sir.
Do you have another one coming?
No, sir, I don't believe so. I have one in Senate Rules today.
Okay. Where's my blueberry pie?
So I will tell you, we're planning on.
You got it.
Mr. Chairman, we're planning on having cobbler on Sunday night. That way, I can bring it up Sunday night and it'll stay frozen.
That sounds like a plan. Look forward to. Yeah, have to wait. I'll just let this one wait too. So. All right. Thank you, sir.
Thank you, Mr. Chairman.
Mr. Advertardy.
Mr. Chairman, Mr. Chairman, Mr. Chairman, I am here to present 319. This is permitless carry. This bill has been upgraded here in the House. Now it's known as the John Meadows Act. Y'all already voted on this bill as it is now. So unless there's any questions, that's it.
See no questions.
And then I won't get into it, but I already presented 326 also.
What's that?
I presented Senate Bill 326 also at an earlier committee.
Oh, right. Okay. Very
Thank
good.
you, Mr. Chairman.
Mr. Kaiser.
Morning, Mr. Chairman, members of the committee. It's a pleasure to be with you. I bring to you Senate Bill 370. It's the very last bill on your calendar under structured rule. This is a tax credit. It's a total of $20 million. It's $2,500 per taxpayer, $5,000 for a married couple to help these foster care support organizations for aging out children that have turned 18 or approaching 18 and been in foster care. Dismal failures with those children these days as far as getting their degrees, even a high school degree, interaction with the criminal justice system, pregnancy. It's been quite a situation trying to get these children into sort of integrated into society. This allows you to give the tax deductible or get a tax credit for contributions to foster care support organizations. And they provide for education, transportation, health care, mentoring, vocational training for these aging out children. Requires that 80% of contributions be paid directly to the benefit of the children rather than creating more government bureaucracy.
Mr. Blackman, did you push your button?
I tried to.
Well, try it again. Okay, go ahead.
I was just going to follow up behind Senator and mention that the House has passed identical legislation already this year as well, so good bill.
Thank you very much.
Okay, now, explain to me how a senator can do a tax credit when it's supposed to start in the House.
I would have more trouble explaining that one, Mr. Chairman. Somebody smarter than I with a legal background might have to dive into it. based on the Constitution and case law, I think that is something that, typically we expect to originate in the House.
Okay. Thanks, sir. Mr. Williams.
Thank you, Mr. Chairman. To the author of the bill and my senator for Walton County, is it not true that this is a good piece of legislation, that your idea is great, and is it not true that that it's in the proper format now with a House bill number and without any changes to your original legislation?
Obviously, I think it's a great idea. I wouldn't spend my time and energy on it. Thank you for your
Well, I think your bill is outstanding. It just needs to have a HB in front of it instead of a SB, since it's related to taxes. Okay?
All right, well, I appreciate your time.
I don't see any other questions. Thank you, sir. How many do you have this year?
Well, I'm just trying to have a grand finale on the way out, Mr. Chairman.
I'm telling you.
And let me tell you, thank you for having me. And being here is like the smell of fresh cut grass on a spring day. It's just wonderful.
Did you mow the grass?
No, sir. My arthritis is acting up this morning, or I would.
I understand.
But but thank you, Mr. Chairman, for having me today. And we're on page 1. About 2/3 way down, Senate Bill 319. And let me tell you, I had the pleasure of this.
No, 259.
259, I'm sorry. I can't see this morning without my glasses. I had the pleasure of having this bill perfected in public safety by Chairman Powell, and I'm just overwhelmed with excitement for that to happen. And he'll be handling this.
What else did you expect out of Chairman Powell?
All good things.
All good.
All good things. All right, this has 3 sections. Section 1, it says that you can't share the weapons carry license information to other agencies or other people, or sell it for solicitation reasons. Second part is that you can shoot your firearm safely on 10 acres or more of your property. You just got to take all safety precautions. You can't shoot at your neighbor's house even if you didn't like them. You got to abide by all the local ordinances and gun safety rules. Everything else is just like it would be. And the third thing is that law enforcement agencies have to auction off all the good weapons in a year period, meaning if it's a bad weapon or illegal weapon like a sawed-off shotgun, you can't auction that off. But we need to get these guns on to law-abiding citizens, and that's what this bill does.
Speaker Pro Tem.
Yes, ma'am.
Yes, Senator. I had a question. How does it change anything with regard to places of worship?
No. Yeah. I'm sorry. The perfection said that churches, and especially in my area, I bet half the members are packing. They're carrying a weapon. So, amen, brother. And so I believe the church can say they don't allow weapons. Whoever owns the church, the congregation, the members, the deacons, different churches are different way. But they have the right to allow or disallow firearms, just like a private property owner. Is that right, Al?
Isn't that currently the case, that they can choose to allow them or not allow them now?
Yes.
So
but this makes it more definite.
How does it change it?
It just allows them to do it the other way, would they'd have to opt out now, or opt in. Now they have to kind of opt out.
So they'd have to put up a sign?
Yeah, if they choose, yeah. Or make an announcement every day, I guess. But that'd be true.
Chairman Powell.
To my friend in the well, is it not true that we cleaned up the church language? There was a mistake that we made, but we were prompted by the governor of several years ago, and that churches are in fact now treated as private property, so they can now make a decision on who they wish to allow to come on that property with or without a weapon. Right now you have churches that are caught in a dilemma, and they have been that way since we did this 7 or 8 years ago, but they're caught in a dilemma that they can't legally assign anyone. Now with this, they'll be able to assign who will be able to have weapons, whether it be a deacon or whatever the desire of that church may be. This is supported, I understand that this is supported by the Georgia Baptist, because of the problems that they've had by so many of their churches. The other language, it would allow the probate judges to create an online application for their concealed weapon license, because even when constitutional carry passes, a lot of us that are involved in Second Amendments, we are still encouraging law-abiding citizens to keep that concealed weapon permit for the purpose of reciprocity and to be able to go to a gun dealer, a licensed gun dealer. And probably one of the areas that's the hardest to explain, and that would be the mental health piece. Right now, your constitutional rights are abrogated to a point if you've ever been deemed a mental health issue. But once that mental health issue is passed, it became a realization to some of us that I had a young man who had a physical condition as a young man at 18. And then that created a mental health issue. When they cured his health problem, his physical health problem, the mental health problem went away. But still, according to Georgia law and the federal laws, it was hard for him to regain his Second Amendment rights, his constitutional rights. This is a process put into place that would allow a process for testimony to the courts so that his constitutional rights could then be restored. Other than that, my dear friend, the chairman, has been pretty accurate on it. This isn't near as sexy to some of the gun folks as constitutional carry, but this is equally as important to help people with their constitutional rights. Certainly.
Yes, ma'am.
When I read the section on churches, I don't see it explicitly written the way you said. I just see things marked out. So currently, a church cannot specify if it wants deacons or such to be the only members to have guns. Is that correct?
That is correct.
So why didn't you just make that change and say that a church could specify?
Because
who
churches
would be able
are
to?
in fact private property, and the least that the government has to do with meddling in religious institutions, the better off we all are. Let them make that decision themselves.
So follow-up, if a very large church wanted to restrict gun carrying to just say paid security, they would have to post a sign that said no guns are allowed except for, paid security, therefore alerting any potential criminals that there are no guns there.
I think part of what you just said is correct.
Okay.
But at the same time, that is also a private piece of property. And there's a half flip on the other side, and then they can't, under the current situation, a lot of the churches, they're restricted from allowing who they wish to have a weapon.
And further question on the 10-acre
Yes, ma'am.
easing of the 10 acres. So currently, for example, in most jurisdictions, there are restrictions within, say, 10 feet of a property line. You can't put up a structure without getting, different types of permit. In this case, I could shoot any legal weapon within 2 inches of the property line. Is that correct?
You can't shoot at the property, the other property.
Within 2 inches of the property line.
Well, I guess so, but I doubt if that would happen too much.
Thank you.
But I think the good lady needs to realize that liability for that person with a weapon does not stop it shooting on that property.
Absolutely. That's true. And that would be important to know if my grandchild were killed, to know after the fact. Thank you.
Okay, Mr. Setzler.
Thank you, Mr. Chairman. To the offer, I wanted to speak to the lady's question about the restriction versus the signs on as it stands today, churches can specify who carries, but it's enforced through what's called criminal trespass. So if a church says, we're going to invoke gun carry abilities on our property, they act as a council and they approve that. So the ability to charge someone with a felony for having a firearm in their property is now gone. The way they then, today, without having to post a sign, they then they appoint certain people, deacons or whoever, to be able to carry, and if someone else carries, they have to tell them to remove themselves or remove their firearm. and that's enforced through criminal trespass. It's not enforced through, bam, you're a felon because you're carrying a firearm. But what happens today, so you don't have to post a sign, the church council simply says, we are authorizing gun carry in general on our property, so no one carrying a firearm is going to be a felon. And then they appoint people who are authorized to do it. Anyone other than that is told to remove their gun, their firearm, and they have to remove themselves. That's enforced by criminal trespass. So that's the state of the law today, which doesn't require churches to post a sign. It does allow them, with a warning, to tell folks to remove themselves. So it's kind of an in-between position. That's the state of the law today.
It does clarify it. Plus, it's all about property owners' rights in that regard, and whatever the church or who owns the church is in charge of that decision.
Thanks.
And also on the other one, any person who fires a firearm has to do it legally, and they can't be pointing it at other people. I mean, anybody, that could happen with any bad guy, any criminal, but we're talking about law-abiding citizens who surely would make good judgment in their targeting or firing their weapon on their property. That's what we're trying to get to. This is brought to us by a Georgia 2A Association, the original language, and plus they used to be called Georgia Carry. So thank you, Mr. Chairman.
Okay. All right. See no more questions. Thank you, sir. Mr. Gann.
Good morning, Mr. Chairman, ladies and gentlemen of the committee. I want to ask your consideration under Senate Bill 510. It's on page 2. And I could think of a lot of things to call this bill, but I'm going to call it the Good Neighbor Bill. Currently under Georgia law, a 16-year-old that as soon as they get their license, they're restricted for that 6 months, that first 6 months, where they can only have immediate family members in the vehicle with them to drive with them. And for me, after that 6-month period, they can have one adult that's over 21 from thenceforward. And what I'm asking the committee to look at is let's let that 6-month period on the back end of that 6 months come forward so that you could have a 21-year-old or above in the vehicle with that 16-year-old driver. And the reason I call it the Good Neighbor Bill, not everybody lives in a metro area where you have Uber or Lyft, but if you had a neighbor that needed to go to the doctor, said they needs a ride, why couldn't that 16-year-old take that neighbor to the doctor or to the grocery store? For me, this is one of the things that when we look at this bill was brought to me by a constituent that his granddaughter was trying to come down Lookout Mountain, and she had to come down by herself. Now, I know some of y'all can remember 16 better than I can, but when you're 16, there's a lot of things that are going on, and for me, having an adult in the car with you, they would provide a lot of security. I've always told my daughter, I said, that when you're most vulnerable is if you have a flat tire and you're worried about changing the tire, somebody can knock you in the head. We have a lot of unscrupulous people out there in traveling the roadways looking for victims to prey on, and I don't think that by moving this up 6 months is going to hurt anybody, because I think that the ultimate decision maker is that parent of that child. I will tell you, I said, just in case you're wondering, if you're an aunt or an uncle to a 16-year-old driver, you can't ride with them right now. Your aunt or your uncle can't ride with that 16-year-old. It's only immediate family members. And so for me, it's just a small tweak in the law. I do think it's most important that we understand, hey, and Representative Jones, I know what it's like when you talk about the loss of a child. Said I've dealt with that firsthand, and I wouldn't want your grandchild or anybody else to have to experience that loss. But for me, this is one of the things I think that parents are the most important decision maker in what happens with that child's life. And for me, all I want to do is try to make the parent have the flexibility to, if they want to let their child drive, they can do that. And for me, I think this is one of those things that the government doesn't need to decide everything. So I would ask for your favorable consideration.
Speaker Pro Tem.
Yes, sir, Mr. Senator. What evidence do you have that this would not be a problem?
Well,
Do you have statistics?
I
from the
don't
highway?
have any fancy statistics or anything to tell you, but I do know we allowed in the second 6 months for a teen to drive with an adult that's above 21 that's not a family member. And for me, there's a lot of us that you know, we don't have access to. I live out in my closest neighbor's half a mile away. If my 91-year-old neighbor needed to ride to the doctor or the grocery store, I would hope that my daughter, when she was 16, could have done this to help a neighbor. And that's why I say it's a good neighbor bill.
I think I would suggest that with regard to teen driving laws, most people are not so much concerned about the parent's decision-making with the teen, but the effect that that teen driving would have on them and their family since they share the road. What would you say to those who might prefer that an inexperienced driver be more limited as current law?
And that's where, when we look, I always will suggest, and I will ask for your help to push for funding for driver's education. For me, I think that's one of the most critical things that we need to provide to new drivers is driver education. I will tell you that one of our folks that works here at the Capitol that runs a driver education school supports the bill. He thinks that it's a good thing. You know, when they've got folks that are in the vehicle that are responsible, that's important. I don't want a carload of folks. I don't want to belabor the point, but I do think it's important that we allow for the youngsters to learn, and it's better to do that with not a car full of teenagers, but just one adult, whether that be an immediate family member or an aunt or an uncle or a neighbor.
Thank
you. Mr. Martin.
Thank you, Senator.
Make your question short and your answer shorter.
Yes, sir. So I think what I'm understanding here is you're interested in the younger driver being able to take a passenger, someone 21 or older, you know, a good neighbor bill, as you said. My question is, what's magic about 21? I mean, a lot of times 21-year-olds may still be close friends. What if that age went up a bit so you did have a more of an adult presence in the car in the first 6 months? I mean, that's an arbitrary difference between 21 and 30, but I mean, clearly I think that would belay some concerns. I think a more adult driver to supervise a 16-year-old. I just asked the gentleman if he might consider that.
A minimum of 5 years difference between 16 and 21. I don't think you'll see a lot of 16 and 21-year-olds socializing a lot, but you know, I'm amenable to that if when it gets to the floor, if you know, somebody wanted to make that change, it's not the end of the world for me, but I do think it's important that we allow the youngsters to learn and do it safely, and that's the critical part about it.
Ms. Hughley.
Thank you, Mr. Chairman. To the author of the bill, we all know that in the first year that a young person has a driver's license, that's when they're going to have their accident. Based on my experience as an insurance agent, that's when they normally have their accident. And the whole thing was to eliminate as much as possible distractions for new drivers as they're trying to learn how to change lanes and do this and that and the other. So why do you think adding somebody who, you know, they're not the driver instruction with the extra brake on the other side, why do you think adding additional people will help with this situation?
Not everybody is talented to be a good driver's ed teacher. Said you know, I can tell you that and I won't pick on any of my immediate family members because they might be listening, but you know, some of us are better at teaching the youngster to drive than others. But if I wanted to teach one of my nieces or nephews to drive, then I couldn't do that with just me and that niece or nephew in the vehicle. And for me, that decision would be made by the parents. The parents are ultimately responsible for what the child's the decision of making them behind the wheel. And for me, that's where the most important part of that whole discussion is the parent. So for me, I want to make sure that you know, if the government would allow it, then that we can do it. And the constituent that brought me this bill, his daughter had just turned 16. She had to come down Lookout Mountain after dark by herself. Now, you know, we do have a restriction, and I'm not changing the restriction for the twilight hours, so that you can't drive between midnight, I believe it is, and I believe it's 6 a.m. or something. No, don't quote me on the times, but I don't want to take that off the table. I want to make sure that that parent is empowered to make the decision for their child.
Okay. Two quick questions and two very quick answers. Chair Lady Cooper.
Thank you to the author. What are the restrictions on age on family members in that first 6 months? Are there a restriction on age?
There are no restrictions on age.
So
a family member 6 years old could ride with a 16-year-old driver?
it seems like we need to be working on that part.
Well, and quite honestly, you know, driving is one of those things that leads to car accidents. I don't care where you are, but if you don't drive, you don't have a car accident. At some point, we realize that, you know, it's important for somebody to learn how to drive if you want to be mobile. And so for me, whether we do it at 16 or 18 or 21, and that's where Representative Cooper, I thank you. Thank you.
Okay, Mr. Benton.
Mr. Chairman, to the senator, would you say that it's probably true that the way the law is written now, that you have to have a family member in the car with you is very seldom enforced by law enforcement?
I don't have any statistics to one way or the other, but I could agree that that's probably the case.
Okay, no more questions. Thank you, sir.
Thank you.
I sure hope you're quick. Mr. Brass. Okay, go ahead.
SB 573 simply requires that hospitals and ambulatory surgical centers have a policy around surgical smoke evacuation systems.
I'm embarrassed. I had asked the other day what surgical smoke was.
Would you like me to tell you again?
No, you do. I know now. I've had it done to me, so. Okay. Any questions? Seeing none. Thank you, sir.
Thank you.
Okay. One little bit of business we have to take care of is we have a rule substitute, Chairman Martin, for Senate Bill 345. It's LC 442101S. 442101S. Chairman Martin.
Yes, sir. Thank you, Mr. Chairman. All this does is on lines 37, 38, and 39, there's just a situation where research universities have federal contracts. There's ongoing litigation. The state has sued to stop the mandate from the federal government, but we want to put that language in so that they are not caught in case during the process of litigation that stay is removed, to put our universities in a situation where they either have to break state law or lose hundreds of millions of dollars in grant funding for research. So with that language, we are protected both ways.
That substitute should be on your desk. Okay. Any questions for the sponsor? Seeing none, I have moved we accept. Got a move and second. All in favor say aye. All opposed, like sign. Okay, it's been approved. All right. Now remember, we're operating under 33.3. All committees or all rules, all legislation has a 1-hour time limit. All right, well, let's set the calendar for day 37, which is tomorrow, day 37, because today's day 36. Okay. Senate Resolution 463. Do I hear a move? Move. All right. Second page, Senate Bill 397. Do I hear a move? Move. You have a move and a second. All in favor say aye. Aye. All opposed, like sign. It's on. Senate Bill 479. Do I hear a move? Move. Got a move and a second. All in favor say aye. Aye. All opposed, like sign. I tell you what, the enthusiasm in this place is just so as a result, Senate Bill 486, it's on. Senate Bill 496, it's on. Senate Bill 534, it's on. Senate Bill 558, it's on. Senate Bill 573, it's on. Senate Bill 586, it's on. And down under structured rules, Senate Bill 330, it's on. Let's read them again so everybody have the right number. Okay. Okay, I left one out. 345, we just voted on. All right, here a move. Got a move and second. All in favor say aye. Aye. All opposed, like sign. It's on. Okay. SR 463, SB 345, SB 397, SB 497, SB 486, SB 496, SB 534, SB 558, SB 573, SB 586, SB 330. But before we leave, where'd he go? I'll get him. Thank you. Meeting's adjourned.